We have here learned counsel for the parties at some length. It is true that the trial court had, while discharging the accused persons under the special act mentioned above, made certain observations about the alleged misuse of the provisions of the said act by unscrupulous elements, and also certain suggestions for remedying that situation. It is also true that the trial court had come to the conclusion that there is no real basis for it to frame any charge against the accused persons under the said act. But it is equally true that while setting aside that order and directing a fresh order on the question of charge, the High Court has clearly mentioned that the trial court shall remain uninfluenced by the observation made in its earlier order. That observation is, in the opinion of the High Court, a sufficient safeguard against any possible prejudice to the complainant applicant herein making transfer of the case from the court at Rohini to any other court unnecessary. Now, in the ordinary course, if an order passed by the court is set aside, the observations and findings recorded therein also get obligated for all intents and purposes. So also, if the High Court makes the position clear that any such observation shall not influence the court concerned while making a fresh order, the same should ordinarily put the matter beyond the pale of any controversy. Having said that, there may still be situations where the nature of the observations made by the court concerned create a reasonable apprehension in the mind of the litigant that the court has so committed itself to a given approach or thought process that it may not be possible for it to retrace its steps to take a fair and non-partisan view in the matter. The present appears to be one such case where, despite the safeguards provided by the High Court's observations, the apprehension of the complainant continues to subsist. We do not think that such apprehension is wholly misconceived, nor can it be dubbed as forum shopping in disguise. The earlier order passed by the trial court is so strongly worded that it could in all likelihood give rise to a reasonable apprehension in the mind of the complainant which cannot be lightly brushed aside. We must hasten to add that we are not in the least suggesting that the presiding officer of the trial court is totally incapable of adopting a fair approach while passing a fresh order, but then the question is not whether the judge is biased or incapable of rising above the earlier observations made by her. The question is whether the apprehension of the complainant is reasonable for us to direct a transfer. Justice must not only be done but must seem to have been done. A lurking suspicion in the mind of the complainant will leave him with a brooding sense of having suffered injustice, not because he had no case, but because the presiding officer had a preconceived notion about it.